All right, so welcome to Professional Ethics, the Plague Edition, the Home Edition, whatever you want to call it. Anyway, we're going to move ahead and take a look at privacy and confidentiality today. And so we start you off with a couple of definitions. First, privacy denotes a zone of inaccessibility. And secondly, confidentiality implies the keeping of secrets. Privacy is considered by many people to be one of the most important rights that we have because, as human beings, we want an opportunity to cordon off an area and call it our own. We don't want people coming into our land, our office, our home without our permission. And in fact, even the idea of personal space, having an area around you where you don't want people crowding you, becomes a very important right. But it's not an inalienable right. It is something that differs and changes from one place to another. Now, there are two court cases that are mentioned there under privacy. One is Boyd versus the U.S. in 1886. The other is Olmstead versus the U.S. in 1928. The case of Olmstead versus the U.S. Is only important for a brief moment, and that is because Justice Brandeis here claims that, and this is in a dissent, mind you, but he claims that this is the most valued and respected right of any civilized individual. And so it puts into record basically just how important we consider this idea of privacy. But the case of Boyd versus the U.S. is a little bit more relevant to us because that's the one that transforms the idea of privacy away from just being about personal space towards the idea of personal information as well. And so this ties up to this concept of confidentiality that we're going to be focusing on here, the keeping of secrets. Within any profession, there are going to be secrets that have to be maintained. You have to be able to speak out to individuals about these secrets. But if confidentiality is there, you're not going to feel comfortable enough to do that. You need, for example, you look at our original three professions, medicine, law, and clergy. Are you going to go to a doctor, for example, and tell him all kinds of personal information, perhaps embarrassing information, if you thought the next time you went into the doctor's office that this information would be all over the place and everybody would be pointing at you and laughing and talking behind your back? No, you're not going to do that. So you want to make sure that confidentiality is there so that you feel comfortable enough to be able to bring this information to the doctor so that they'll be able to help you. If that confidentiality is there, you may not even come seek the help that you need. But as important as confidentiality is, some people talk about there being limits to it. And so the case that we're going to look at here is Tarasoff versus the Regents of the University of California, which was heard by the California Supreme Court in July of 1976. It involves events that took place in 1969. A young woman called Tatiana Tarasoff was dating a young man called Prosenjit Podar, and their relationship had taken a negative turn. He became very aggressive, very possessive, and he essentially made it known when she tried to leave that if he was not going to have her, nobody was. And so she wants to get out of there. Now, she probably should have gone to the police and explained what was going on and got a restraining order or something like that, but she doesn't. She tells her parents, and her parents are going to send her out of the country to live with relatives for a few months. In the meanwhile, Podar is going to check himself into a facility at the University of California where three psychologists are going to look after him. And these three psychologists are going to say that he is a dangerous individual. He has made threats, and he is the type of person who will carry through with those threats. And they feel that he should be confined. They try to have him picked up a little bit later by campus police, but they're forced to let him go because they have nothing to hold him on. The supervisor of those three psychologists, Dr. Powelson, said that in order to have him confined or put into a facility or anything else, they would have to violate his confidentiality, and legally that could not be done. So Podar was let go. In the meanwhile, Tatiana comes back into the country unaware of anything that's been going on. The two meet up, they have an argument, and he ends up killing her. Well, as a result of that, of course, her parents are going to bring a lot of charges, but specifically they're going to try to level 4 charges against the University of California. Failure to detain a dangerous person. They argue that since these psychologists claimed that Podar was dangerous, they should have confined him. Failure to warn on a dangerous person. Even if they couldn't have him confined, couldn't they have told the parents? Couldn't they have told someone so something could be done? Thirdly, abandonment of a dangerous person. Even if we forget about Tatiana, this man was a patient, and by letting him go, they put him in a situation where he could commit this crime and now has to face the penalty for it. And fourthly, breach of primary duty to the public and the patient and the public. And so by putting him out there, he's been put in a situation where the public at large might be in peril based upon his actions. Now, the Supreme Court, of course, gets to decide what it wants to hear, so it decides that it's only going to look at point 2 because it wants to make an argument with regards to the issue of confidentiality. Now, the majority opinion in the case is in your book on page 239, and it's written by Justice Tobrenner, and the dissenting view is on page 245, and that comes to us through William Clark. The ultimate decision was an 8-1 decision, the majority saying that confidentiality should have been violated in order to save the life of this young woman, whereas the one dissenting voice in this is Justice Clark, who says, no, they did what the law demands. Now, looking at this strictly from the standpoint of the law, Clark is completely right. The law in 1969 did not have any exception whatsoever to the rule of confidentiality. It was absolute. Now, in the meantime, between 69 and 76, when the case is heard, laws had changed in the state of California, which means that, by the standards of 1976, they would have been wrong. But we have to judge a case, as Clark points out, by the laws that are on the books when the crime took place, which means that those psychiatrists did what they were supposed to do. They maintained confidentiality. That was the law. As you would expect in these cases, the law is going to take precedence here for the most part. And on page 241 in your text, in the second column, it mentions that the common law has traditionally imposed liability only if the defendant bears some special relationship to the dangerous person or to the potential victim. Now, because there is a direct relationship between Podar and Tatiana, it seems that by their understanding, there should have been some kind of protection taken into account. They argue that it is, of course, very important to maintain confidentiality, but they also point out here on page 243 in the second column that if we look at the law, we'll see that there is reason why confidentiality should have been violated. In Evidence Code Section 1024, the legislature created a specific and limited exception to the psychotherapist-patient privilege. There is no privilege if the psychotherapist has reasonable cause to believe that the patient is in such mental or emotional condition as to be dangerous to himself or to the person or property of another, and that disclosure of that communication is necessary to prevent the threatened danger. So there they argue that within this evidence code, there is reason to violate confidentiality if there is a genuine threat or danger being seen. They point out at the bottom of that page that the American Medical Association in 1957 wrote that a physician may not reveal the confidence entrusted to him in the course of medical attendance unless he is required to do so by law or unless it becomes necessary in order to protect the welfare of the individual or of the community. Now, granted, that's not law, but it shows that even within the medical profession, there is that possibility of violating confidentiality. And so the majority decision's effect says, we conclude that the public policy favoring protection of the confidential character of the patient's psychotherapist communications must yield to the extent to which disclosure is essential to avert danger to others. The protective privilege ends where our public peril begins. And so basically the majority says that these psychologists were wrong. They should have violated Podar's confidentiality in order to try to do something to save the life of Tatiana. Well, Justice Clark is the one dissenting voice in this, and he argues, I think correctly, that the majority has allowed their emotions, they've allowed their feelings to cloud their duty. They are legislating from the bench, and that's not what the court is supposed to do. The court is supposed to uphold the law. And the law in 1969 was very clear. There is no reason, there is no legal capacity for violating confidentiality whatsoever. He points out on page 245 in the second column, reflecting legislative recognition that disclosing confidences impairs effective treatment of the mentally ill, and thus is contrary to the best interest of society, the Act establishes the therapist's duty to not disclose. Section 5328 provides in part that all information and records obtained in this course of providing services to either voluntary or involuntary recipients of services shall be confidential. That is what the law said in 1969. Period. No exception. A little further down, he points out that in 1970 there were two exceptions that were made to this rule. Section 5328 was amended in subsection G to allow disclosure to governmental law enforcement agencies as needed for the protection of the federal and state elective constitutional officers and their families. So in 1970, the law was changed and said that if these threats were made against an elected official, that confidentiality could be violated to the appropriate authorities. Of course, Tatiana was not an elected official, so even if you took that into account, it would not change the law in her case. It also says 5328 Section 3 was added to provide that when necessary for the protection of the patient or others due to the patient's disappearance from, without prior notice to, a designated facility, and his whereabouts is unknown, notice of such disappearance may be made to relatives and governmental law enforcement agencies designated by the physician in charge of the patient or the professional person in charge of the facility or his designee. So, if Podar had been an escapee under the 1970 law, then yes, he could have, his confidentiality could have been violated. But the fact is, he was not. So that means, that even if we took into account these 1970 changes to the law, which we shouldn't, but even if we did, it would not change anything. The law was clear. Confidentiality must be maintained. Now, Clark says that he understands the emotional feelings that are being shown here, that it's terrible what happened to this young woman, but he says that from a legal standpoint as well as from a moral standpoint, it is crucial that we maintain the idea of confidentiality. Going too far in this. Let's see if we can get back to the right screen here. There we go. There are three reasons why Clark gives that confidentiality is so crucial. First, people who need that may not be willing to seek it. So just like we were talking about before, if you are somebody who needs the help of a psychiatrist or a doctor or any professional, you may not be willing to come forward and reveal this information to this person so they can help you unless there is confidentiality in place. So if we don't have confidentiality, then those people who need help may not be willing to seek it. Secondly, those people who are seeking help might withhold vital information. So even if these people do choose to come forward to seek help, it's not going to change anything because they may not be willing to reveal the most necessary information unless they know that what they say is going to remain confidential. And thirdly, it allows a trust to build between the doctor and the patient. When you go to a psychiatrist, the first 2-3 sessions have very little to do with your problem. It's simply building a rapport. It's building a sense of trust between yourself and between your doctor. And so that is very important reasoning, according to Clark, as to why confidentiality is crucial not just to psychiatry, but to the whole medical profession. And that if we start poking holes in the rule of confidentiality and allowing people to violate it, then what we're going to end up doing is undermining the ability of those professionals to do their job and to be as effective as they could be. And so his statement here at 247 says, given the importance of confidentiality to the practice of psychiatry, it becomes clear that the duty to warn imposed by the majority will cripple the use and the effectiveness of psychiatry. Many people, potentially violent yet susceptible to treatment, will be deterred from seeking it. Those seeking it will be inhibited from making revelations necessary to effective treatment, and forcing the psychiatrist to violate the patient's trust will destroy the interpersonal relationship by which treatment is affected. And so Clark argues that these psychiatrists did exactly what the law dictates that they should, that they were in the right in this instance, and that not only legally but morally, the doctors did what was necessary, which was to maintain confidentiality. Had Tatiana gone to the police herself? Had she filled out a complaint? Had she gotten a restraining order? Something could have been done because she would have been the one bringing that information public. But it is not the place of the psychiatrist to violate the man's confidentiality. It's unfortunate what happens to her. It should not have happened. But these psychiatrists cannot be held, and psychologists cannot be held accountable for what has happened here. They followed the law, and they looked out for the greatest interest of their profession. Okay. Unfortunately, these videos only allow me to record for about 18 minutes, so I'm going to have to stop at this point, but I will be back with some very important information in the next video, so please watch that one.